Hello and welcome to episode 5 of Estate Planning Weekly. I am your host, Don Rolfe. I'm the owner and founder of Northwest Legal Planning, an estate planning and probate law firm located in Portland, Oregon. This show is all about answering the most common questions I receive regarding estate planning. And this week we're going to cover the topic of how to leave money to minors generally. So the reason that we broach this topic is that a lot of people that have minor children are worried about making sure that anything they pass on to them before they reach adulthood is going to be there to sustain them and support them. The most common method is that people name their children in a will as beneficiaries to inherit, or if they don't have a will, then the state statutes for intestacy, which means that you've passed along without a will, leaves it to the minor children outright. And the problem with that in Oregon and most other states is that children can't own and inherit money and be in control of it until they're at the age of majority, which is 18 here in Oregon. So if it's left to them outright in a will or outright due to their parents passing without a will, it's going to require that a conservator be appointed to manage that money for the minor. And if you haven't done proper planning, you're not going to be the one that's going to pick that conservator. So the best way to leave money to minor children is in a trust. And you will pick the person who will manage that money for that minor child. And that person can be completely separate from the person that you name to be the guardian of your minor child. And in that way, you can select a guardian who has your same philosophies, beliefs, faith, or other things that are important to you, belief in education, without worrying about whether or not they're good at managing finances or whether or not they have the finances themselves to take on the care of your children. And you name a trustee of your child's trust, a person that you trust and knows your philosophy for how you want those funds to be spent on your children, what kind of schools you want them to go to, what kind of after-school programs, music, sports, other educational pursuits, other perhaps vacation pursuits, and that person that is managing the money will be able to make sure that the money is used in the ways that you had anticipated and desired. Granted, they're still going to be responsible for providing to the guardian money for standard living type expenses, food, clothes, all of those sorts of things that you want to provide and you would have provided if you hadn't untimely passed away. So, to sum it up, in order to make sure that your beneficiaries, your minor beneficiaries, receive funds with the least amount of work involved and to create the best atmosphere, it's really best to leave minors money in a trust. It can be a trust that continues or one that terminates once they reach the age of majority. But during the time that they're a minor, it's important that it's in a trust. That'll keep the courts out of it. It'll allow you to select who is going to be managing that money for them, and it should make what would be a horrible and devastating situation in your child's life at least a little smoother of a transition for those people who are going to be caring for your children. If you have any questions about this topic or any other estate planning topic, please feel free to reach out to me. If you follow the link down below, you can schedule a 30-minute telephone or in-person complimentary consultation with me. And if you have any other questions, please feel free to reach out to me via email at don@nwlplanning.com. Until next week, thank you, and I'll see you then.